Please, Your Lordship.
Yes, Mr. Amit.
My Lord, the virus of the act enacted by district council is under challenge. But the amendment, my Lord, amendment is under challenge. Now, the petitioner has admitted that the district council has power to enact the Act of 2006, my Lord. And amendment is also amendment has been done with the assent of the governor. That is also admitted. What is being said that the local headmen have not been consulted. This is the ground of challenge, my Lord. I have drafted a short reply, my Lord. I will file the short reply, my Lord, during the course of the day or within because reply is ready, my Lord. Placing all these materials that the consent has been obtained by the Honorable Governor. And the ground that there is no consultation with the Ilaka or etc., my Lord, is no ground for challenging the virus of the Act. Either it is against beyond the competence or it is violative of fundamental right, my Lord. That is no ground has
Yes.
been taken in this
The
case.
matter is taken up for hearing. Advocate General, Mr. Amit, submitted that a short a reply, don't say short, reply has already been prepared and he'll file it in the course of the day. Full stop. Post the matter on so and so date.
Grateful.
My Lord, this matter, the SLB filed by the party, it is coming up on 22nd July, my Lord. May I pray for adjournment?
On an agenda.
Madam, so is the order.
Request of so pose the matter.
Then Lordship will come in the first week of August, Lordship.
Huh?
First week of August.
Yes.
Yes. Give it up.
All right, Lordship.
Item
What
number
is given? For you or
Order
for
passed
us?
by the Supreme Court, my Lord. Order passed by the Supreme
Order
Court.
of the
notice.
Supreme
it is
Court.
not this, Lordship.
The matter is coming there, coming up.
Coming up on the 22nd of July.
Identical issue.
Well, the notice was
Lordship,
issued on
again,
26th April. Notice was issued on 26th April, my Lord.
Similar matter is coming up.
No,
This is
Lordship,
the thing,
against
my
the
Lord.
order.
Party, the appellant has filed the SLP,
Ah,
my Lord, and the Honorable Court has issued notice to the state.
so what is the Supreme Court matter has got to do with the present appeal?
Lordship,
My Lordship has passed an order accepting the application filed by the state. Implement
Again, you have gone to the Supreme Court.
Yes, my Lord, regarding that.
Again, the order of this court, dated so and so, impleading the parties, SLP has been filed, and the matter is pending before the court. You same. Registry is that plus the matter on so and so date.
Give it, Judge.
Item number 3.
This is your Lordship. In this matter, Lordship, we filed our reply to the petition.
My Lord, we wish to file a small reply to the objection filed by the respondent.
You want to file objections? This is with regard to felling of trees.
Yes, Your Lordship.
It is represented by the government advocate.
No, Your Lordship, he's the PIL petitioner.
I'm for the petitioner. my Lord.
You said,
Oh,
we are referring to
Lordship.
submission,
Lordship, yes.
government pleader, that a reply has been filed to the PIL on that. Full stop. The council of opinion submitted that reply to the counter filed by the government. Was the matter on so and so date.
Lordship. Obliged.
Item number 4 and 5.
Here for the petitioner. My Lord, this writ petition, my Lord, in fact challenges, my Lord, two notifications. By the first notification, there has been an amendment effected to the Meghalaya bonded warehouse rules by inserting, my Lord, a new clause Roman 2A in rule. And by the second notification of the same date, my Lord, the Meghalaya excise rules have been amended. Now, my Lord, so far as this matter is concerned, this was argued quite extensively earlier. And my Lord, for all practical purposes, your Lordships have formed an opinion that, my Lord, the writ petition deserves to be allowed. My Lord, may I draw your Lordship's attention to, my Lord, one of the orders passed by your Lordship's bench, my Lord, on 20th June 2023. May I start with that?
20th June.
Yes, my Lord, 20th June 2023.
With regard to the maintainability of the writ petition.
No, my Lord, the maintainability is now decided. My Lord, with regard to the merits also, my Lord, several observations have been made, which
Where
in my
is it?
respective
Where is the
20th
order? Date of the order?
my Lord, the order should be, my Lord, on the records, but my Lord, I can ask my local
No,
advocate,
date of
my
the
Lord.
order, sir.
Yes, my Lord, may I just read the order? My Lord, the respondent number 3 has disclosed its partnership deed, which reveals that there are 4
20th
partners.
June.
Now, the respondent number 3,
1 minute, sir. We'll try to take out the judgment. Order. Oh,
26. When do you
yes, sir.
my Lord, initially, my Lord, so far as the manufacturers and
appearing?
bottlers.
Who is appearing on the other side?
I am appearing, my lord, for the
Amit
state,
Kumar.
my lord. I am
state.
appearing for the state.
My lord, I am appearing for respondent number 3, my lord.
My lord, with greatest respect, my lord, the issue has not been decided. What my friend is saying, that issue has already been decided.
That
It's
is
not
for your
correct.
lordships to consider. I want to make submissions on that.
So the issue is, the entire issue is open before your lordship. The entire case is open. There is
Yes,
no
well, I
discussion
would
on
like to argue that. I am, my lord, starting my arguments on that.
Yes. All of you are ready.
Yes,
Well, I am ready.
we are all ready.
Sir? We'll come. So we'll post it next week. We'll also read and come. We'll read and come.
Very well, my lord.
This is what that some judgment, some distillery's case was also quoted. Correct? Some
Yes, ma'am.
Yes, ma'am.
distillery,
Yes,
or
ma'am.
some quoted distillery. Some judgment was also
Yes,
put.
ma'am.
This is the case, Yes, ma'am.
Yes,
Yes,
my lord.
my lord.
Post the matters sometime next week. Convenient of the lawyers, or the first week of July. We hear. Circulate the paper, madam.
My lord, first week of July will not be suitable, my lord. If your lordship can take it up, my lord, on 15th of July. We in
Yes.
Guwahati having a holiday, my lord.
Yes, post on
Yeah.
sponsor, we'll see. We'll check the dates.
I just want the matter heard, my lord. I want, my lord, your lordships to, my lord, take it up at any convenient time. Matter has been pending for a long time. Many orders have been passed in the matter. Your lordship will kindly, my lord, take it up at
No,
any convenient time.
we'll also come prepared so that it'll be easy for us to pose questions.
Very well, man.
See, yesterday I was not here, otherwise I would have read the papers.
My lord.
Yes,
Lord, item 5 is connected. I appear for the petitioner therein.
same date.
My lord, lordships are fixing it on, my lord, any particular date?
Yes, so we'll check the dates and give it to the council on record here. Your friend wants on 15, we'll check 15th on, we'll post it on.
But I don't mind it on the 15th, but, my lord,
We'll check.
let it be, my lord. Let my landlord friends, my lord, agree to, my lord, start the hearing and finish it.
So week commencing from 22 to 25, we have got one or
My
two
lord.
only. 22nd, Monday,
My lord,
Monday,
very
22nd,
good, Monday.
22, 23, 24, any day, 25.
Yes, my lord, 22, 23,
My lord,
24,
22 is
any day is good.
22, any day.
23rd.
Very well.
23rd of any day, my lord, convenient to us.
Yes,
23rd.
July.
July.
Great, my lord.
We're going to check any government holidays are falling on this week. That week. Yes.
Item number 6.
Lord, in this matter, my Lord, Lord, permission was granted, although it's not reflected in the order, my Lord, to file an additional affidavit. My Lord, we have filed it just now, my Lord, it's before the registry. My Lord, I have just served the copy, my Lord.
I've received the copy, Your Lordship.
It is represented by counsel appearing for the respondent. That additional affidavit has been filed
Yes, my Lord.
today. This morning, only, not today, this morning. Copy has been served on the respondent. The registry is directed to tag that additional affidavit along with this paper book. Post on so and so date.
Item number 7.
Obliged, my Lord.
Yes.
This appeal again is, my lord, directed against the order of conviction, my lord, where I'm sentenced to life imprisonment for an offence under 302, my lord. I'm sentenced to life imprisonment for an offence under 302 IPC, my lord. I'm my lord, praying for a short accommodation, my lord. not been able to prepare it well. Maybe a week's time, my lord.
Appellate. What's the matter on so and so date?
on the daily list. Item number 1.
May I please, Your Lordship? The instant appeal has been preferred in the impugned judgment and order dated 31/12/2022, filed in WPC number 128 of 2017, my lord. Pardon, my lord, the
Who's on the
appeal.
other side? You have not filed any reply to the appeal?
So you say generally we are in this writ appeal. We are
Sir?
not in general leadership in this writ appeal. We are not filing the reply.
You're not going to give any list of events. This is order of Central Administrative Tribunal.
No,
it is
no, my lord.
Oh, Central Administrative Tribunal means it will come before division bench, correct?
So this is from.
Here it is from, my lord, competent, they are competent. Therefore, initially,
Yes.
they approve before the single judge,
Yes,
not single judge.
Assam Rifles.
Assam Rifles, my lord.
So you're going to file that. In the midst of the argument, don't take time. If you want to file, we'll give you time now.
In fact, my lord, relief was granted. Initially, they approved along with 1,338 clerical competent staff before this honorable court. Relief was granted by the learned single judge, division judge. Slight modification is made by the division bench. That area should be restricted from the date of filing of the writ petition. Thereafter, they went to the Assam Union of India went to Supreme Court. Supreme Court even passed a detailed order, not in limine SLP was dismissed, but passed a detailed order. Thereafter, they have implemented the judgment on 21/6/2016, my lord. They have given two reliefs are claimed that there should be petitioners, the appellant should be given rank, status, and pay. That relief was granted on 21/6/2016 by the Ministry of Home Affairs after consultation with the Ministry of Finance. And immediately on the next day, 22/6/2016, the one of the relief was withdrawn. One of the relief was withdrawn, my lord. Even after when the judgment was attained finality, when the judgment was
What
attained,
the order passed by the learned single judge?
learned single judge has dismissed my petition, my writ petition. Subsequently, we have approached, my lord. Before the learned single judge, their judgment, my lord, with my humble submission, it is a contradictory judgment. And my humble submission that, my lord, when a judgment was passed by the Honorable Supreme Court by a detailed order, my lord, speaking order, and that is amount to, my lord, even if your lordship, I can show your lordship one or two orders of the Ministry of Home Affairs. If your lordship permit me, one or two orders.
Sir,
Your Lordship, here in this case, they are asking.
you're ready. You're not going to file any statement.
Your Lordship, I will filing Your Lordship.
See, what is his contention to his contention that the Supreme Court has already granted the relief? How can you withdraw it?
No, Your Lordship, this is not correct. This is not correct, Your Lordship. Because in the Assam Rifle, to have the second in command, this department.
Give the list of events. Give the list of events.
But
If you're not,
one-
otherwise you give the list of events.
My lord, one or two orders I can show. Only, my lord, only.
Give the list of events, sir. We are going having all the papers. We want the dates. See, from day one, the bench is saying where I am sitting, wherever I am sitting, whichever bench I am sitting, I've been saying that give us a list of events. So it will be easy for us to pass orders.
All right.
How many employees are there?
Here, my lord, one of the appellant has, out of 1,338, one of the appellant here prepared this.
Only one
Yes,
appellant has come.
Only one
One person has come.
out of one. They have given the relief partly, my lord. They have given the, your lordship will be surprised how the order was withdrawn. If I show only one order, my lord.
You show me. Show us.
My lord, only two orders. Sorry, my lord, two orders. 32. 128. Lordship, Supreme Court judgment is page 128. I'm showing.
One?
Page Supreme Court judgment 128. Which,
128.
yes, 128.
120, yes.
128, my lord.
128.
Yes, my lord.
Oh, yes.
That is the Supreme Court judgment.
Yes.
Thereafter, your lordship, by passing learned single judge order has been restored. Slight modification was made, but
So after this order, the order has been complied with.
complied. And next page was obtained. My lord, I am saying that next page, 130, page 130. My lord, I am reading it, my lord. That will, my lord, clinch everything, my lord. This is a order of Ministry of Home Affairs. In the bottom, date is there, 19/2/2016, my lord. Subject. Implementation of judgment and order dated 23/8/2012 of Honorable High Court, Meghalaya, Shillong bench.
131 or 130?
My lord.
Page 131 or 130?
130, my lord.
Oh,
130.
yes.
Yes. Yes, my lord. That is in the bottom, your lordship will find the date, 19/2/2016. After the Supreme Court disposed of the matter, thereafter they have passed. I am reading from my lord, para 2 onwards, my lord. My lord, as the instant case, Assam Rifle has agreed to implement the judgment and order dated 23 August 2012 of Honorable High Court of Meghalaya, Shillong bench, passed in WPC number 277 of 2010, filed by Naib Subedar Clerk Radhakrishnan Nair and others, Assam Rifles, 1,338 others, versus Union of India and others, by introducing the rank of warrant officer, ASI, as the anti-grade with effect from 1/186 in respect of clerical cadre enrolled prior to 29/10/2002 to bring, lordship, this is very important, to bring parity in respect of pay, rank and status of Assam Rifle clerical cadre at par with other CPF. The next para 3 mile. As regards second part of the judgment, that is promotion avenues up to the rank of second in command at par with counterpart in different CAPF, Assam Rifle has intimated that it is not applicable as parity in the upper line of rank structure is only up to Subedar Major in Assam Rifle. Hence the highest rank permissible to clerk will be Subedar Major. We wanted that it should be second in command, that is Group A post. Now para 4 mile. Their observation, it is Ministry of Home Affairs observation. As the issue is promotion, avenues up to the rank of 2IC in clerical cadre in Assam Rifle is requested to submit this issue in a separate file with adequate justification whether promotion avenue of clerical cadre in Assam Rifle is to be extended up to 2IC rank or restricted up to Subedar Major. This line is very important. As implementation, the one part of the judgment and order of the High Court, leaving other parties contradictory. It is their observation in February 2016, my lord. February 2016. They said, because our two pairs were there, we should be given other CPO rank, status and pay. The entry grade is assistant sub inspector, that is equivalent to warrant officer. Assistant sub inspector equal to, and periodic promotion, that was the specific pair before the learned single judge, and both were allowed, my lord. And periodic promotion up to the rank of second in command, my lord. That was available in other central paramilitary forces. That is Group A post. Here, my lord, it is Subedar Major. In Assam Rifle, it is Subedar Major. It is Group B post. Subedar Major is a Group B post. And that was allowed by the learned single judge, upheld by the division bench, also upheld by the Supreme Court. Now, your lordship, this after it is February 2016. Now, your lordship, in the next order, page 131, this judgment was implemented, granting us both the benefit, rank status of assistant sub inspector, that is the warrant officer, as well as the second in command. In the lordship will find, and to capture the matter, your lordship, there are 2 onwards I am reading. Para 1 the undersigned is directed to refer to the issue of authorizations regarding implementation of judgment and order dated 23/8/2012 of Honorable High Court of Meghalaya, Shillong Bench, passed in WPC number
4 is enough.
Enough, my lord. Thereafter, it was passed on 21/6/2016. After 4 months, when it is they themselves say it is otherwise it will be contradictory. On the next day, all of a sudden, surprisingly, the second in command benefit of periodic promotion was withdrawn. That is the interim order. On the next day, my lord. Page 132, your lordship. There is order dated 22/6. They say para 3, your lordship will find. Para 3, the matter has been re-examined and it has been observed that extending promotional avenues to the Naib Subedar up to 2IC level was not a part of the judgment dated 23/8/2012 of Honorable High Court of Meghalaya, and this was not proposed by MHA either while MHA had recommended the case of implementation of the High Court order dated 23/8/2012. This stipulation promotion avenues up to the rank of second in command at par with their counterparts in different CPF under the Ministry of Home Affairs aided by Ministry of Finance. MHA is in the process of taking up the case with Ministry of Finance for seeking clarification division in their decision. Meanwhile, Assam may implement the decision conveyed by dated 21/6/2016 only to the extent of implementation of the judgment and order dated of the Honorable High Court of Meghalaya Shillong Bench upheld by the Honorable Supreme Court. My lord, all of a sudden, the benefit of rank when parity does not mean only in the lower cadre, only in the lower level. Parity means each and every rank. And that was clarified by the Supreme Court in another judgment. This was clarified by another judgment of the Supreme Court, my lord. I have brought a list of document judgment, my lord. There your lordship will find 1-to-1 parity. Even pre-commission recommendation also I have brought. 1-to-1 parity, and that was previously now it is done. And they have admitted in the Ministry of that 19-2 order, they admitted leaving one part of the judgment and prayer in the original writ petition. I can show your lordship prayer in the original writ petition and the judgment of the original in the earlier case, in the earlier round of case. That will make clear, my lord, abundantly clear. Therein, my lord, in the first case.
What do you say, sir?
My lord?
See, when an order has become final,
You
it has to be seen from page number 128. How can you put you should have sought for a clarification or you should have filed a review.
It is temporary with the judgment.
Your lordship, here in this case, your lordship, the petitioner asking the rank of second in command, which is as per our retributive note.
Sir, we'll take it that the order is wrong. We'll take your submission that the order is wrong. The original order is wrong, not this order. That has been affirmed by the Supreme Court. Unless you get it clarified by means of filing a review, clarification means by filing a review, and they get the order properly corrected. How can you pass an order? You think that you are a Supreme Court, above Supreme Court?
No, your lordship.
Then?
We are not. Your lordship, here in this
The
case,
Supreme Court has confirmed the order.
your lordship,
Following the Surendra Kumar case, are so saying that the same principle should apply. That's what in page 128 says.
your lordship in fifth pay commission, your lordship,
That's it. Please take page 128. Please take page 128. This is the order of the Supreme Court. 129. See. The order so and so. Surendra Kumar and Union of India disposed of the same terms and directions as in SLP number so and so.
so your lordship, here in this case, the first when this matter has come up, then this is the regarding this pay scale in introduction in the pay scale in 1997.
That's what we are asking, sir. Assuming that there is an error committed by the single judge, or by the division bench, or by the Supreme Court, you should have filed a review. Having accepted and implemented, how can you go back? Isn't it?
Take part of the judgment. They say it was not a part of the judgment. And his part was included by the Ministry of Finance.
So it was not a part of subject matter. See, what is here to page number 132, but you have to give the list of dates. Page number 132, it says the issue was not part of the judgment dated 23 to 28.
It is very much part. I am showing from the record itself, my lord. I am showing right now. I'll show, my lord, your lordship. I'll show. Lordship, look into my prayer in the writ petition, original writ petition, prayer in the original writ petition. It is a prayer, specific prayer was there. I am saying. 12 of the writ appeal, my lord. Page 12 of the writ appeal. Prayer is quoted for ready reference. What was the prayer and what was the reaction?
Ministry. You have to see the clarification.
That is proposal to see clarification 2016. This project can be.
So what is here to para number 4 at page 132?
Yes, Your Lordship. I got it. Got your Lordship point. I got. I'm saying that what is the judgment, what is the operative part of the judgment, and what is the prayer before the learned single judge. Lordship will look into page 12 of my writ appeal.
The first.
Yes, in the first proceeding.
Page number 12.
Page number 12 of the writ appeal. What was the prayer and what was the reaction? Page 12, my lord. Para 14, my lord. Para 14, I have put the prayer.
Para 12.
Page 12, my lord. Para 14.
Page 12, para 14.
Yes. My lord, there is what is the prayer before the learned single judge? That situations of the petitioner along with the other similarly situated employees approach the Honorable Guwahati High Court, WPC number so-and-so, issuance of a writ of mandamus directing or commanding the respondent to bring about parity in respect of the personnel of Assam Rifle clerical cadre at par with other central police organization at the entry grade with effect from 1/1/86 or from any other date as deemed fit and proper for granting same pay scale of 1320 to 2014 1/1/86 or rupees 4,600 1/1/96 and same rank and status ASI warrant officer which are admissible to the personnel of the clerical cadre of BSF, CSF, etc. and also bring parity in respect of rank structure in accordance with the grades with effect from 1 and also the periodic promotion. Thereafter up to the rank of second in command. Second in command in the light of the Government of India, Ministry of Finance, resolution dated 29/97, communicated through MHA letter bearing number so and so, then second prayer. Issue a writ of mandamus directing the respondent to grant the pay scale of ASI clerk to the petitioner with effect from
What did it put into your file?
My lord, this is what happened when the relief was taken there.
No, only one writ petition.
One writ petition.
But how can you seek 3 mandamus in one writ petition?
No, that is the same prayer, my lord, or more or less same prayer. Only a periodic command in the first prayer taken same petition. Same prayer. Lordship may look into same prayer. Because in other central penal assistant sub inspector is the entry grade and promotion avenue up to the rank of second in command. Same prayer. Lordship may kindly look into same prayer. Same prayer. There is no, my lord, separate prayer. Now the judgment, your lordship. Judgment, I am saying the learned single judge judgment.
Please give the list. So give the list of events. So it will be easy for us to write the judgment also.
My lord, even the judgment of the learned single judge, I am saying just one page, my lord. Thereafter,
that is an appeal.
No, that judgment attained finality, which attained finality, that judgment, which attained finality. Learned single judge judgment initially went to this division bench. Division bench are upheld. Only notification that area should be given from the date of filing writ petition, and thereafter Supreme Court. The Supreme Court may only look into the single judge judgment is operative part started.
Also, you must understand one thing. You are having about 500 pages. You are taking us to one page.
I'll find it.
So give us the list of events so that it's easy that see, junior can prepare and give it. It's not the first time we are saying. Give us a list of events.
I'll do it. I'll do that. I'll do that.
What he says, when the issue has attained finality, And he says that this prayer was available at the point of time. See, my brother was also pointing out to me, and we have posed a question to him stating that this was not a part of the issue in the earlier round of litigation. That is why they passed a subsequent order at page number 131 or 132. 132 or 133, whatever it is.
So you see here this 130 onward.
Enable the parties to file the list of events. See, in service law, in all matters, more so in service law, we require a list of events. It will be very easy, sir, very easy for us to pass orders.
I am surprised, my lord. Even after passing the order, implementing the order, they have withdrawn the order next day.
That is wrong. We have to render a finding.
My lord.
We will not be searching. We are not going to suppose.
I'll place that, my lord. I'll place that.
We have to dictate the order.
My lord.
Because the matter again may go to the Supreme Court.
My lord.
Is it not?
Because all the employees are 1,330.
You may not go. They have funds. They go to the Supreme Court.
They have funds even my appellants, they are also pressing me very hard to place all these things before for an urgent hearing and all these things.
But we will pass orders. You give the list of events.
My
You could have prepared earlier.
My lord, let
It
it
will be
come.
very easy for us to pass orders. Each page on whatever the relevant pages. List of events. When did he join? How many cases?
Even putting those judgments and paragraphs, my lord.
No, but not required. Relevant paragraph you mentioned, that is enough. You need not reproduce it and give it another typeset. List of events should be list of events. That's all.
Even with all respect, my lord, even the single judge judgment is self-contradictory.
See, it is our prerogative right to write a wrong judgment. It's our prerogative right to write a wrong judgment.
Yes, that is there. That is there. My lord, can it come on
get it corrected?
second week of July, my lord?
Second week, yes. Second week or third week. 17th is a holiday. Following week.
15, my lord, 15 July.
Oh, any day. 22nd July. 22nd July. 1 week thereafter.
Monday.
My lord.
That week, I think there's some holiday is coming.
My lord. Deeply obliged to us.
You give the dates of events.
Right.
You circulate to him. Let him not say that you have given it at the 11th hour.
Deeply obliged.
You also see, you may be appealing for the department, but you owe duty to the court. You are an officer of the court. When a decision has been taken and that his prayer appears to be a comprehensive one, but a detailed one.
Here in this this in 1997, there was lots of litigation as regard to this pay of the Assembly of the Assam Rifle as well as the CPF. There was what's happening in this case. The Lance Nayak was merged with the Havildar, and subsequently it is come dated with the warrant officer. So problem lies there. Out of these cases come up. So the position of the warrant officer already is given.
Give us the list of events.
Yes,
Take the list of events from him. Then you point out the mistakes there. Your order needs to be sustained. And say that the order of the learned single is correct. We need the list of events.
Even they have filed an affidavit before the Supreme Court in KK Dination case, admitted that there are disparities with other central paramilitaries, with the Assam Rifle employees. And then Supreme Court given a direction, 1-to-1 parity should be made.
I say that the KK Dination case, the contempt is also considered in that case? Contempt petition, KK Dination? It's not so.
No.
This is only with regard to parity issue.
Parity.
Yes.
Yes.
Another
And it says,
no, there is one other KK Dination case is there, where they consider about the contempt issue. That is not there in this case.
No.
That is also KK Dination.
Yeah, my lord, in KK Dination says that what it must be at par with all the central paramilitaries has come under the same umbrella it should be 1-to-1 parity. Even I have brought the 6th Pay Commission recommendation where it says 1-to-1 parity should be maintained with all central paramilitary forces. Among the central paramilitary, 1-to-1 parity.
Single bench order in this case. Single bench, the order which has been mentioned here. Isn't that the proposition of law which this it's applicable to the only to have not up to words. That is really what it is. That the original order, the earlier order which is
That is why they passed an order saying that it is not being covered in the earlier.
that will get clarified.
This is a list of events.
Learned Sage says, my lord, the officer grade was not dealt. Officer grade was not dealt with in the judgment. Even Group B is the Subedar Major is a Group B officer. Our promotion revenue as per the existing rules, it is up to Subedar Major. Even Subedar Major, we are Group C. Subedar Major is also Group B. So, Learned Civil Judge observed that group officers cadre was not dealt with. The Assam Rifle is restricted with the promotion avenue up to the Subedar Major. Subedar Major is a Group B post, Group B officer. Nowadays, even Group D abolished, all are officers.
Yes.
Deeply obliged, Your Lordship.
In Assam Rifle, it is not abolished, Your Lordship. Still it is there as per it rule.
Give the events.
I'll do that. Deeply obliged, Your Lordship.
Circulate it also so that we will also read and come.
I'll give it.
Not only to your friend, for us also.
Yes, my lord.
So it will be easy for us to read and come.
My lord, I'll do that.
Because I have got more time to read.
Deeply obliged.
Yes.